The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Well, good morning and welcome to this remote session of the North Carolina Court of Appeals. I'm Richard Jeets and I'm joined by my colleagues, Judge Valerie Zachary and Judge Allegra Collins. On the public calendar for today, this morning, there were 3 oral arguments scheduled, but just for the benefit of anyone public that may be viewing this argument, 2 of those were removed from the calendar, so we'll only be hearing 1 case for oral argument this morning, and that is State versus Carver, number 19-1055, and I understand the parties are ready to proceed, so with that, we'll hear from the state. Mr. Hyde, you're muted.
Can you hear me now? Yeah, I'm going to start over. May it please the court, my name is Joe Hyde. I represent the state as the appellant in this matter. I'd like to reserve 5 minutes of my time for rebuttal. This case is really about the DNA evidence. The DNA evidence is the one component that the 2 claims have in common upon which the trial court granted defendant relief. The trial court found that the defendant showed ineffective assistance of counsel in counsel's failure to question his own expert's opinion on the state's DNA evidence. The trial court found newly discovered evidence in defendant's new expert opinion that the state's DNA evidence was not accurate, not reliable. Now, the legislature has provided a mechanism for a defendant to challenge DNA evidence that was introduced in a prior trial. That mechanism appears at 15A-269. It allows a defendant to file a post-conviction motion for DNA testing upon allegation that the DNA was previously tested, but the requested DNA test would provide results that are significantly more accurate and probative of the identity of the perpetrator. That avenue apparently remains open to this defendant. The trial court erred, however, in allowing a new trial, absent some evidence that there would be a more favorable result from new DNA testing.
Let me interrupt you, and before we get to that, I have some jurisdictional questions, and I think if this was an in-person oral argument, I would interrupt you, lead you through a series of questions, try to make a point. I've observed that in these remote oral arguments, that's not a very good use of our time. So what I'll do is I'll sort of channel my inner Justice Breyer here. Let me ask kind of a long question for a minute or so
Sure.
that sets everything up. Assume that I would have gone back and forth with you to establish these things, and then I'll get to sort of the heart of the question. So we are constantly entertaining requests by litigants to hear issues in an appeal where there's an order that has more than one ruling in it. One of those rulings, there's an appeal by right. And the litigant will say, you should also hear these other issues as well. So the most common setting is suits against the government. The government or a public official like a law enforcement officer says, motion to dismiss sovereign immunity. Motion to dismiss failure to state a claim on which relief can be granted. When that happens, the trial court says, motion denied, and the state or that public official appeals and says, well, I have a right to appeal sovereign immunity. It's a huge waste of judicial resources not to also hear my appeal of the denial of the motion to dismiss on 12b6 or failure to state a claim, because if I'm right about that, it'll avoid the need to have further things. There's an appeal already, so there's no waste of resources at the appellate level or no delay. So surely judicial economy means you should hear both of these. And we, in those cases, constantly dismiss and say, we're sorry, there's no pendant appellate jurisdiction in the North Carolina Court of Appeals. So if you don't have a right on this other ruling, even if they were in the same order, we only hear the part that you're allowed to appeal. So your friend for Mr. Carver is going to say, this is that type of case because the legislature said there's a right to appeal one type of ruling in this case, but not the other, not the ineffective assistance of counsel claim. That must be pursued through a cert petition. And the state has not filed a cert petition in this case. And therefore, what should happen is we should decline to hear the ineffective assistance claim. And if we don't hear the ineffective assistance claim, there's really no point in hearing the newly discovered evidence claim because it will have no practical effect on the outcome. There will still be a new trial, which gets us into this mootness issue that you've seen in the appellee brief. So with all that background, explain to me why we should be persuaded from essentially what's some language in Peterson that we can hear without granting cert the ineffective assistance claim.
Thank you, Your Honor. Yeah, the first issue I was going to address is defendant's motion to dismiss. It is worth pointing out the defendant himself has filed a cert petition. So if this court agrees with the defendant that it can't review the order by direct appeal, it can always review the order by cert. But I would like to point out the defendant's argument there is based on a fundamentally flawed premise. This court does not review issues. It does not review legal questions. The vehicle for appellate review is an order or judgment. That's apparent from the statutes that provide this court jurisdiction. In 7A, appeal lies of this court from any order or judgment from which appeal is authorized by statute. It's apparent from the rules of appellate procedure, appellate rule 4. A party entitled to appeal from a judgment or order in a criminal case may take appeal by giving oral notice of appeal or written notice of appeal. And it's worth pointing out, defendant has pointed out no defect in the state's written notice of appeal here. Finally, it's apparent from Chapter 15A, the statute that gives the state a right to appeal here states, the state may appeal from the Superior Court to the Appellate Division upon the granting of a motion for a new trial on the ground of newly discovered evidence or newly available evidence. That's what happened here. The trial court granted a new trial on the ground of newly discovered or newly available evidence. The statute does not say the state's right to appeal is limited to the issue of newly discovered evidence. What has to be understood from the terminology of that statute is where there is an order or judgment granting a new trial on the basis of newly discovered evidence, that order or judgment may be appealed by the state to the appellate division. And that's what Peterson, I'm sorry, is it Peterson? That's what Peterson held. Peterson's, there's a situation, Peterson, the defendant filed an MAR, trial court granted the MAR on the basis of constitutional violations as well as newly discovered evidence. And upon review, this court held the trial court had entered an appealable order because the trial court granted the MAR based in part on newly discovered evidence. That's a direct quote. That right to appeal does not come from Peterson. The right to appeal comes from the statute that Peterson correctly interpreted to mean that where there is an order granting a new trial on the basis of newly discovered evidence, as there was here, then the state has a right to appeal.
So let me jump in, and I do want to ask you a couple questions. The first is, if there was no newly discovered evidence ruling, if the only ruling was ineffective assistance of counsel and grant of a motion for appropriate relief on that basis, could the state file a notice of appeal?
They could file a notice of appeal, but I think that situation would be much more open to an attack as there not being a statute that provides the state the right to appeal.
Right, because in fact, isn't it the case that ineffective assistance actually is almost like it stands in contrast to newly discovered evidence? If the evidence reasonably could have been discovered by counsel, it can't be newly discovered evidence. And so the two are in conflict in some ways.
They are, and defendant himself recognized that in his motion for appropriate relief when he presented those claims in the alternative. Your Honor is precisely correct. Those claims can't sit together.
But you see then there's tension in the statutory language, because if the legislature wanted the courts to be able to review ineffective assistance of counsel claims through notice of appeal as a matter of appeal by right, they could have said that. And instead they seem to choose one subject matter area, which is newly discovered evidence, and said you can have a right to appeal there only on legal questions. And everything else, including ineffective assistance, your only path is having the court issue a writ of certiorari. And aren't we undermining that if we recognize that a notice of appeal on newly discovered evidence can pull with it, through pendant appellate jurisdiction, other issues that wouldn't otherwise be reviewable with the notice of appeal?
Well, I have two answers to that, Judge Dietz. The first is, with all due respect, the statute is not ambiguous. There's no tension in the statute. The statute says the state may appeal upon the granting of a motion for a new trial on the ground of newly discovered evidence. The trial court here granted a new trial on the basis of newly discovered evidence. That means the state has a right to appeal that order, not the issue. It's not issue specific, as in 15A 1444 that says, for example, the defendant who pled guilty may appeal only certain issues to the appellate division. The legislature certainly knows how to divide them out that way. It did not do that here. The second response is, even if that argument had some traction, absent Peterson, this court now could not rule consistent with that argument without overruling the holding of Peterson that said where the trial court grants the MAR in part on the basis of newly discovered evidence, that order is appealable as a matter of right by the state.
And that's where I think your friend for Mr. Carver is going to say, well, that's how Howard clarified Peterson and removed the tension by saying what Peterson actually holds is that when the issues are inextricably linked, that in that circumstance, you can bring them all up, which is consistent with case law in other areas involving this concept of pendent appellate jurisdiction. So if the rulings are all kind of linked together like that, then they can come up and be reviewed. But
Howard denied a motion to dismiss. Howard denied a motion to dismiss on this basis, citing Peterson. There's the suggestion that Howard somehow limited Peterson or cabined it to a particular rationale is not supported by the ultimate ruling in Howard, which denied the motion to dismiss and dismissed the state's conditional petition for cert. So the suggestion that Howard somehow changed the holding of Peterson or injected some kind of ambiguity in the statute is not supported by the ruling in Howard itself. Howard denied
the argument. I view the argument as you can harmonize those two cases and the general principle that the states, we strictly construe statutes permitting the state to appeal in criminal matters, and that all of that can be harmonized together by bringing in this inextricable link concept. And then the problem, I think the argument we'll hear is the problem you have in this case is far from being inextricably linked there. In some cases, they contrast with each other because the ineffective assistance and the newly discovered evidence, as I pointed out, are somewhat in tension. So you typically would not have both for the same issue because you'd have to be one or the other. And so I think that's the argument we're going to hear.
I would just reiterate what I said before, that this statute is not issue specific. At least insofar as it does not limit this court's jurisdiction to reviewing particular issues. And to impose that restriction on the statutory language, contrary to Peterson's reasonable interpretation of the statute, I don't think would be justified, particularly where Howard denied a motion to dismiss raising that very argument. I guess the fallback position is it's true that the claim...
Excuse me, Mr. Hyde. I just want to make sure I understand this. What you're saying then, in a nutshell, is that if the state can appeal the order, then any argument is fair game.
Any argument that was raised and ruled upon below, Judge Young.
Okay, all right. On any issue.
So long as the trial court granted a new trial on the basis of newly discovered evidence.
So are you saying then that the ineffective assistance to counsel claim is only appealable by the state because it included a newly discovered evidence component?
Yes.
Okay.
That's right. Because the order ruled on both claims under the language of Peterson, because the trial court granted defendants MAR based in part on newly discovered evidence, the state had a right to appeal the order.
Now, what happened if there were two orders? Same, everything happened in the trial court, just issued two.
That's an interesting question. I'm not sure why a trial court would issue two orders granting a new trial. I mean, I guess it's conceivable. I think I would have a harder argument in that case. But I would return to the premise that it's the order or judgments that is the vehicle for appeal. So in that situation, the state would still have a right to appeal the order that granted a new trial on the basis of newly discovered evidence. It might be necessary to file a petition for cert if there is an entirely separate order. But that's not what happened here. With this court's permission, I would like to go on the two issues involved in this case are the ineffective assistance of counsel claim and the newly discovered evidence claim. And Judge Dietz, as you pointed out, those claims, they are a little bit in tension. The fact that they're inconsistent, however, does not mean they're not inextricably linked. In fact, the trial court kind of tied itself in knots applying the test for newly discovered evidence because it couldn't find, or at least didn't find, that due diligence was used and proper means were employed to procure the testimony at trial, which is the IAC element that sort of appears in that test. Let me back up and address the ineffective assistance of counsel claim first. The trial court cited the United States Supreme Court case in Wiggins, which is the case that says counsel has an obligation to conduct a reasonable investigation. Reasonable investigation into the facts and law with which his client is charged. The trial court relied on Wiggins, and defendant relies heavily on Wiggins in his brief before this court. The case that the state is relying on is State v. Frog, which is a North Carolina Supreme Court case that distinguished Wiggins. And the important distinguishing factor there is that Frog involved a situation where the defense counsel had an expert and was relying on the expert's recommendation in not pursuing a further investigation. That's precisely what happened here. The trial court actually faulted counsel for not familiarizing themselves, for not educating themselves on DNA evidence. That's why we have experts. Attorneys are not competent or expected to know all of the nuances of a science that is advancing as quickly as DNA science is. We rely on expert opinions. And the defense counsel here at the post-conviction hearing testified that they relied on the opinion of Ostrowski, the DNA expert who had been recommended according to the testimony by IDS.
Well, that's a question I have. Was there evidence presented that IDS recommended Ostrowski?
It's a little unclear, but I feel like I think there was, Your Honor.
Where's?
Yeah.
If you know,
No,
I
I've
don't
got
want to
it.
take up all your time.
It's in the state's reply brief. I'm sorry, if you'll give me just a moment.
I have another IAC question as well. So.
I'm sorry, I'm having trouble finding it right now.
Okay. Well, that's all right. Another question I had is you state in your brief that the defendant did not want to get a psychiatric evaluation or talk to the defendant's psychiatrist. That defense counsel didn't want to do that because it would be prejudicial to the defendant at trial.
Oh, absolutely.
How would just talking to defendant's psychiatrist or getting the defendant a psychiatric evaluation prejudice him at trial?
Well, talking to the psychologist perhaps might not, but that's what goes to the heart of the problem here, is that the trial court found defective performance without any findings or conclusions as to prejudice. So had defense counsel gone and talked to the defendant's psychologist, we would have found out, for example, that he had attacked his son and fought with him for something like 45 minutes. There was some evidence that he had previously shot his son, that he had discharged a firearm in the house, that he was under treatment for psychiatric, for paranoid delusions, I think is what it was. It's not so much the failure to talk to the psychiatrist, but if defense counsel had attempted to put some of that evidence on, you can imagine the bonanza that the state would have had in cross-examination.
But
counsel explained. Sorry.
Well, I was just going to say, but that wasn't quite my question. I think my question was getting the records. You know, why would defense counsel? Why would it prejudice defendant for defense counsel to just get a psychiatric evaluation or get his records?
Right. I'm not sure it would have prejudiced him just to get the records, but in terms of at least obtaining an expert opinion, as with the DNA opinion, that opinion would have had to go on in the defendant's case file, and perhaps have been disclosed in discovery to the state. And I feel like if the state had learned that there was some pursuit of that evidence by the defendant, particularly with the DNA evidence, if the state had learned that the defendant's own expert agreed with the state's DNA evidence, can you imagine a scenario where the prosecutor would not have called the expert that the defendant consulted? You agree with the state's DNA evidence? There are very good reasons why those further investigations were not undergone here. Counsel explained that at the post-conviction hearing. And unlike in Wiggins pointed out, the Supreme Court pointed out, said there was not a situation with a double edge, I think is the term they used. This mitigation evidence about the defendant's family history. There was no downside of pursuing that investigation. There wasn't something that the state could have leaped on and used against the defendant. That's very different in this case, because each one of those further investigations that the trial court found counsel failed to pursue, the psychological investigation, the physical and intellectual disability, particularly the failure to familiarize themselves with DNA evidence, to question the opinion of their own expert. Each one of those things created an avenue for cross-examination that would have been devastating at trial. Devastating. And trial court.
Let me understand your argument. I think one of your arguments is that the trial court failed to make a finding on prejudice, correct?
That's right.
Okay. And then I think what I'm hearing also is that you couldn't make a finding of prejudice because of what you have just talked about, correct?
That's correct, Your Honor. And that argument appears in the state's brief. Not only was there no finding of prejudice, but a finding of prejudice could not reasonably have been made.
Okay. So in this case, can we infer from the fact that he granted the MAR that he did in fact determine there was prejudice, and thus we're looking de novo, or we're looking abuse of discretion? How are we viewing the evidence that you're giving and the fact that there was no specific finding of prejudice?
I think the only reasonable interpretation, Your Honor, is just a misapprehension of law. I guess it's possible to assume that the trial court knew that a prejudice showing was required and made those findings sub silentio, but it doesn't appear in the order. In fact, there's no indication that the trial court actually understood that the defendant had to show prejudice in order to prevail on an IAC claim. And I think part of the reason that that finding wasn't made is the difficulty involved in reaching that conclusion. If you actually look at each one of those pieces of evidence, each one of the things that the trial court found counsel failed to do, there's no way that those things actually prejudice the defendant at trial, because trial counsel during the post-conviction hearing explained why their strategy justified a reasonable limitation on further investigation into each one of those areas. I would like would the remedy in this case be to remand for the trial court to consider whether a defendant was prejudiced because it was a misapprehension of law and we just don't look on the cold record? Or are you saying that we need to make this decision here? That's certainly possible, Your Honor. I feel like there's it's up to this court what it wants to do with the order. I think at least a remand is necessary to allow the trial court to found that no prejudice possibly could have been shown. And I think it is also apparent from the record, and this court could find in the first instance, that there's no way that each one of these alleged failures that the trial court found could have prejudiced defendant at trial, given the explanation provided by trial counsel. That each one of those things could not have reasonably resulted in changing the mind of a single juror. I also want to point out real quick, the trial court's findings of fact, several of them are not supported by evidence. The defendant in its brief doesn't point to any evidence supporting those findings that the state has challenged. The trial court found that counsel failed to obtain any information regarding defendant's health-related issues. Counsel testified that they were aware of defendant's carpal tunnel syndrome. They were aware that he claimed to be disabled. Counsel did not believe he was disabled. The trial court found that counsel failed to interview any family members or friends. It's true that the 5 or 6 family members and friends that testified at the post-conviction hearing claimed that they had not been interviewed by counsel. But the finding that the counsel failed to interview any family members or friends is not supported by evidence where counsel testified they talked to defendant's family members. Finally, the trial court found that counsel failed to investigate, familiarize themselves with DNA evidence. Ratchford testified that Ostrowski instructed him and he relied on the expert opinion of Ostrowski. Frog says it is not deficient performance to rely on your own expert's opinion. Counsel is not required to shop around until they find an expert that will provide a more favorable opinion. Ostrowski agreed with the state's interpretation of the DNA evidence, and counsel made a reasonable decision in not looking any further. Their own expert agreed with the state's expert.
I'm so sorry. Can I take you back to the discussion that we were having about the language of 15A 1445?
Sure.
And when I'm reading the language here, under A, it says the state may appeal from the Superior Court to the Appellate Division. And then under 2, it says, upon the granting of a motion for a new trial on the ground of newly discovered or newly available evidence, but only on questions of law. So is it your interpretation that if a new trial is granted for those reasons, the state can appeal anything and actually doesn't even have to question whether the granting of the motion on the newly discovered evidence was correct? Because if you read the wording of that language, I think that's a reasonable interpretation given your interpretation that anything goes once it's granted for that.
That's correct, Your Honor, but in that scenario, you would have the mootness problem that the defendants pointed out. If the trial court granted a new trial on the basis of newly discovered evidence and other grounds, and the state were to appeal the order on that hook and then challenge only the other grounds, without challenging the newly discovered evidence finding, there was a sufficient basis to affirm the trial court's order regardless of the state's challenge. So yes, that could happen, but it wouldn't be a very plausible strategy for the state in that instance.
Okay, so again, just to understand your argument, once a new trial is granted for newly discovered evidence, absolutely any other issue that was brought up can be bootstrapped in that appeal. Even though it doesn't say order there, it doesn't say appeal and order.
You're right, it does not. But I think that language has to be inferred from all the other statutes that speak to this court's jurisdiction and the right of a party to appeal. It's on the basis of an order or judgment. This was an order that granted a new trial on the basis of newly discovered evidence. That means that order as a vehicle is appealable by the state. It's not, review is not issue specific. Not only does the statute mean that, that's what Peterson held.
Well, I hate to take you back to the very beginning, but that was my point in my initial question, is that's actually, the argument you're making is not a correct one. So for example, in an order denying a motion to dismiss on the ground of sovereign immunity and also denying a motion to dismiss based on failure to state a claim, only the sovereign immunity issue can be appealed to this court. We won't take through pendent appellate jurisdiction the 12b6 issue, even though it's part of the same order. And so I'm not sure you're right in that categorical statement that order means order, and if you can appeal one issue in an order, the court has to hear every issue in the order.
That's fair. I think Peterson said that. I mean, I guess the fallback position here, there is a petition for cert pending with this court, so this court can always grant the petition for cert and review the order. In the few minutes that I have left, the newly discovered evidence test, I think, is most obviously flawed legally. The trial court just omitted entirely the fourth factor. More problematically than that, perhaps, it found that Noureddin's report, testimony, and opinions did not tend only to contradict evidence at trial. What's the point of Noureddin's report if not to contradict the state's DNA evidence? That's the whole reason they called Noureddin. That's the whole reason they got an expert opinion. So the suggestion that Noureddin's report, testimony, and opinions do not contradict the state's DNA evidence is frivolous. The state would respectfully request that this court reverse the trial court's order granting a new trial and allow defendant to pursue his claim through a motion for post-conviction DNA evidence.
Mr. Hyde, I have one last question.
Please.
Do you concede that the court can't review defendants' Brady and misrepresentation claims where there's no findings of fact on those issues?
Do I agree that there are no findings?
Yeah. Do you agree that we can't review it? Agree that we can't review defendants' Brady and misrepresentation claims?
I would like to agree with you, Your Honor, but I have relied more often than I'd like to say on the rule that this court is permitted to affirm on any legal basis available to it. So if this court were to reject the state's challenge to the newly discovered evidence and ineffective assistance of counsel claim, and were to find plausible some of defendants' arguments, I think it could affirm the order on those bases. I would rather that it didn't, but I think legally it could.
Where there's no findings of fact on those issues?
Well, that's a problem.
Okay, thank you.
Thank you.
All right, we'll hear from the appellee.
May it please the court, I represent Mark Carver. To the first point regarding the newly discovered evidence and ineffective assistance to counsel claimed, I would completely disagree with the state's position. The statutes are very specific. When the statutes are specific and the language is clear that there are limitations to appeal, that stands. Peterson does not conflict with that. Peterson found that the issues that were being heard were inextricably connected. There was a nexus in those issues. Additionally, Howard was remanded, and on remand, those issues were all found to be connected. So the newly discovered evidence is the only reason the state can appeal, and only on the conclusion of law, not on the findings of fact. So we would agree that because there's an ineffective assistance to counsel claim, in addition, that the court found that the state's appeal should be dismissed as moot.
I have a question about Peterson. Was that a holding that this court will address other issues that come up when there's a new trial, or was that dicta? And in fact, in Peterson, they didn't even reach the issues that they said they could hear.
In Peterson, Peterson held that the issues were connected. The newly discovered evidence was connected to the other claims that were being raised. So they heard everything. So in this case, that's very different. The ineffective assistance to counsel claim is completely separate from newly discovered evidence claim. Whether the counsel investigated and met the Wiggins requirements or even Strickland requirements is completely separate from the newly discovered evidence of the standards of analysis of DNA mixtures. So there is no connection between the two issues.
I think the point Judge Collins was making, or the question she was asking, was at the end of the analysis in Peterson, though, the court said, and since you win on newly discovered evidence, we don't need to reach any of these other issues. And if those issues were not necessary for the court's ultimate holding, I think the question is, well, then was the jurisdictional analysis of whether we can consider that as issues, is that really a holding in the case, or is that also dicta because the only holding is we can address newly discovered evidence, the statute says so, and you win on newly discovered evidence?
Well, in Peterson, there was a PWC that was filed. So the state did file a petition for cert to make sure that jurisdiction on the Brady issue was covered. So there was that protection. The state here says, well, the defendant filed a petition for cert, but we filed a petition for cert on 3 issues that are unrelated to the ineffective assistance to counsel claim. So because we file a petition for cert, it doesn't mean that they can just throw on any other claim because it's not the full order that is being looked at. It is the individual issues. And that's very evident for defendants when they want to appeal after they've pled guilty. In Pimentel, all the claims were dismissed other than the sentencing issue that the statute specifically allowed for the right of appeal. So we do not agree that there's a right of appeal on the ineffective assistance to counsel, that the PWC we filed allows the state to ride onto that, or that the issues between the newly discovered evidence or the ineffective assistance to counsel are connected in any way.
Well, I also heard your friend for the state argue that we don't even need to really worry about Peterson because we can just rely on the general principle that you don't appeal rulings in North Carolina, you appeal judgments or orders, and that once a judgment or order is appealable, then everything in that judgment or order is before the appellate court, in terms of jurisdiction at least. And here, there's no question that the statute authorizes an appeal of this order that includes the newly discovered evidence ruling. So everything's fair game. What's your response to that?
My response to that is that the precedent and the statutes are clear. When there's statutory construction is that the language is clear, that is what you go with. And the statutes have specifically outlined under 15A 1445 when the state can appeal, and under 15A when the defendant can appeal when they plead guilty. So they have defined the rules for when appeals can be established. and then Peterson and Howard, I think, just affirm that there is a statutory limitation to what issues can be appealed when there's a motion for appropriate relief that's been properly granted with findings of fact and conclusions of law. And to that point, we would disagree that the judge does not have findings of fact on these two, or conclusions of law on these two issues. When the court says that the evidence was relevant, that establishes prejudice. When the court says the defense has met their burden, that establishes that the burden on the second prong of prejudice has been met. So,
but you agree that there is no specific finding that the defendant was prejudiced thereby?
Your Honor, I actually think there is a finding. With regard to the ineffective assistance of counsel, and clearly the findings of fact are very clear, and when the court says any, the state has taken the position, well, there's some evidence that the defense attorney determined on his own that that Mr. Carver was competent without doing any investigation or obtaining any records. And the state says there is evidence that he talked to the family members. Talking is not interviewing. And the 5 closest family members, the only family members, the 2 brothers, the 2 daughters, the sister-in-law, were the ones that testified at the MAR hearing. So there's no family members that he could have talked to.
Did the trial court use the word prejudice?
The trial court used the word relevant, and the finding of prejudice in the prong for newly discovered evidence that requires the finding of prejudice, the trial court said relevant.
So the trial court did not use the word prejudice?
The trial court does not specifically use the word prejudice. As I said, the trial court does say the burden is met, but this court under Cornell has the ability to read or to find prejudice based on the trial court's wording using the word relevant and that the burden has been met.
But one problem that we've run into here is, so if what you're arguing is that we can, as a legal matter, determine that there's was indeed a reasonable probability that but for the deficient performance, the result would have been different. We can determine that by just looking at the record and making that legal determination ourselves. But it seems like there are some fact issues that need to be resolved for that. And not only can this court not find facts just at a high level in any case, but we're instructed by statute here that we can't consider factual issues. We're only looking at legal questions. So this court's really looking to the trial court's order to give us everything we need to say, yes, here's the prejudice. And I think Judge Collins' point is, where do we find that here? Because just a piece of evidence might have been relevant isn't enough to say, well, then it also means there's a reasonable probability that that piece of evidence would have changed the outcome. Before that, the outcome would be different. So how do we get there?
Your Honor, the trial court is not just saying that a piece of evidence is relevant. What the trial court is saying is that the things that the counsel did not do go to the very issues that are important in this case. When it comes to the physical issues, to not do any research, to not get any medical records, to not speak to anybody, when the key issue in this case is you have a young, vibrant, healthy woman who's been strangled with 3 ligatures, and you have 2 men, one of whom has already had 2 heart attacks and can barely breathe. You have another one who's had multiple surgeries for carpal and radial tunnel and is being looked at for another surgery, has been to the doctor that very day with a finding that he has asthma and is overweight. That is not just a finding. That is the key. One of the key issues in this case is the strength required to commit this crime. And there were many steps the counsel could have taken to completely discredit the ability to commit this crime. And then with regard to intellect, again, it's not just a finding with intellect. So when the court is discussing the medical history, the court specifically ends with, sorry, Your Honor. This is the same language with regard to the intellect. It is relevant to the strength required. Then, I'm sorry, to the medical. With the intellect, it is relevant to the evidence that was presented by the state with regard to whether he knew the height of the victim and if he described the victim as a little thing or a little bitty thing, or if he was mimicking the FBI agent who was questioning him because of his IQ issues, but ranged from 63 or 68 to 73 by the state's own evidence. He was very susceptible to that suggestion. So
let me see if I can paraphrase your argument. The findings of fact would certainly support a finding or a conclusion of prejudice, and because the trial court granted the MAR based on IAC, that it was clear that the trial court determined that there was prejudice, and so we don't need that word in the order.
I think the word is there. I don't think the word prejudice is there. I think finding that the actions taken were not actions that addressed the three important issues in this case: the touch DNA, the intellect, and the medical condition. When he says relevant, they're in action.
But you would agree that there could be, in any other case, a finding that a piece of evidence is relevant, but not prejudiced such that the outcome would be different.
I would agree, but I don't think that's what's happened in this case. It's not that he's specifically.
But my question was that there's a possibility in a different case where the term relevant would not be synonymous with prejudicial when we're looking at an IAC claim.
The evidence could be relevant without being enough to overturn. Exactly, yes. Okay. But in this case, I do not think that is the case. And I don't think that's what the judge is saying when he says the burden has been met.
Okay.
So, in summary, with regard to newly discovered evidence and the ineffective assistance of counsel claim, we do not believe there is a right of appeal for the state for the ineffective assistance of counsel claim. We believe the newly discovered evidence claim can only be reviewed on the conclusions of law, and because the IAC claim stands regardless of the NDAE claim, that the appeal should be dismissed as moot.
Excuse me, I have a factual question. How do you respond to the state's contention that defendant opposes retesting the DNA?
Your Honor, this is not a retesting case. This is a reanalysis of a test that was already conducted. The defendant doesn't have to oppose DNA testing. If the state wanted to retest, they could retest. And if this is set for trial, they can retest. This is a reanalysis of the results that were available and presented to the jury in the court at the time of trial without opposition.
So as a matter of law, is that the kind of newly discovered evidence that you think the legislature had in mind?
The newly discovered evidence is that Hall and Rhodes set out the 7 factors. The statute is very specific with its language regarding unavailable or couldn't have been available due diligence. The state references Nickerson. I do not believe Nickerson is. I believe the language of the Nickerson with regard to newly discovered evidence is actually dicta. So I think the portion, the analysis that's important is what the statute says, and then the factors established by Hall and Rhodes. In this case, the state lab is on the stand presenting evidence, and even if the defense counsel had done some investigation, we would have had a battle of the experts on what the results said. But the state lab actually adopted the new standards in 2013 that make this evidence under analysis completely inconclusive and worthless. So it's because the state adopted the new standards in 2013 that the analysis becomes important as newly discovered evidence. And to say that a defendant who's tried when standards are available somewhere else but not implemented by our own state lab, a defendant who's innocent and is then precluded from challenging the changes that the state finally adopts as newly discovered evidence, it would block every avenue for him to prove his innocence when the state it's the state's delay that caused the problem.
So just so I understand factually, draw the line for me. What evidence is there an argument that it could have, when the exercise of reasonable diligence, been discovered before and therefore cannot be newly discovered evidence? And what's the evidence that is newly discovered and could not, with reasonable diligence, have been discovered before? Where's the line there in this evidence?
Well, I think in this case, the line here is that our state lab did not have a stochastic value at that point in time. SWGDAM was issued prior to trial, and the analysis of the second round of testing was done after SWGDAM, but the state lab had not adopted that stochastic value. So the jury was going to be presented with evidence that says this is how evidence is being analyzed in every county by every district attorney against every defendant in our state. That is pretty hard to overcome, even if changes are being made in other states or guidelines have been issued by the federal government, which is why it's important that our state lab keep up with the standards in science.
All right, so in every instance, obviously technology, we're going to make advances in technology, we're going to make advances in science, we're going to make all kinds of advances, and we're going to continue to do so. Is that always going to be newly discovered evidence when a different and better test can be applied to any evidence that's gathered? Will that always be newly discovered evidence in the future? Is there some sort of line to draw when that is or is not newly discovered? Because I can see this applying in a lot of instances.
Well, Your Honor, if it's a matter of testing, then there is this testing statute that you can go to for testing that would give you the new evidence that can then be evaluated under 15A270. But in this case, it's not about new testing. If this was about tool mark analysis, footwear analysis, bite mark analysis, there may not be testing that's needed. It is the advances in the scientific community and what is accepted as science and what is rejected as not being something that can implicate somebody that can be presented as new evidence because of the scientific community's acceptance.
Okay, so if we're to talk about, say, ballistic markings, if in the future we determine that those are not reliable science, does everybody who in that trial had ballistics evidence entered in that trial, do they now have newly discovered evidence and we go back and review their cases?
If they get a scientist who is qualified and looks at the evidence and has a different result, that would be a type of analysis. It doesn't just throw everything out. You still have to have some analysis. If the conclusion was from the scientific community, there is no way to match a bullet to a gun, then that would be different. That is not where we are on ballistics matching right now. It is the detail that is required and the documentation that's required for that comparison to be accurate. But that I would say that would be a testing case, not a change in science, and not a change in scientific opinion. And even on the bite mark, what is required and what you have to take into consideration has changed. So you'd have to reanalyze the teeth marks, what was said to be teeth marks. If there's no other questions on ineffective assistance of counsel or newly discovered evidence, I would like to move on to our petition for cert. I understand that our position is that the judge's order should stand. And I understand the judicial resources and the need to, if there's one issue that upholds a trial court, then there's no reason to reach the other issues. But the importance of these issues are growing, particularly with regard to the NAPU evidence. Of the three issues that we've raised, to me, the NAPU is the most important, because in this case, the state's theory, I won't even go to the state's theory. I will go to the state's complete misrepresentations and prejudice. I mean, and perjured testimony, really. There was at the trial court, the officer said there were no fingerprints that could be compared to anybody. There were no fingerprints of value. The state says there was just a misspeaking, misreading of what he said. But what the officer actually said with the state's questioning, continued questioning, was the prints could not be compared to Mr. Carver or Mr. Casada. That was untrue. The prints had been compared to Mr. Carver and Mr. Casada, and they had been eliminated. The state elicited testimony that the victim was wet. There were 24 people at the crime scene, police reports from everybody. Not one report says the victim was wet. So we have an important fact that is then used to say that's why the Mr. Carver and Mr. Casada's DNA was not on the ligatures, because she was taken to the river and that DNA was washed off. That is a fact that is presented to the jury with absolutely no support at all. It was ineffective assistance of counsel not to challenge it, but even if it was ineffective assistance of counsel, it was a statement, a false statement made by the states with knowledge by the prosecutor.
So your position that we can resolve, because of course that these aren't issues that the trial court expressly reasoned about and rejected, right? These are just issues not addressed by the or the court findings, for example, that we can rely on for these issues. Is it your position that these are just such core questions of law that we can take them up without an order from the trial court resolving some of the facts?
Thank you for that question, Your Honor. Actually, because the court specifically says we didn't meet the burden, but makes no findings of fact, we believe it should be remanded for those issues to be addressed. Those three issues do not have any findings of fact in the court's order, and they are critically important to the justice system. So if we constantly address the issues that are easiest for us to address, and then avoid the questions that really have the impact of the justice system, we're not doing the best we can for the justice system in this case and in all others. So it's our position that the case should be remanded to the trial court for findings of fact with regard to the Brady and the NAPU, and the court's position that they cannot find innocence in a case. I just want to mention a few more things with regard to the NAPU. The hearing test, where it was used over and over again that Mr. Carver had to have heard this accident. The prosecutor himself conducted this experiment, and the state tries to minimize the value of those tests by saying top of the embankment. They were at the top of the embankment versus the bottom of the embankment. The embankment is the embankment. That is the part at the river. That is where they were. That is where the victim was. That is where Mr. Carver was. There is no difference in position when these tests were taken. So the prosecutor elicited this false testimony from Addison Terry, knowing himself that you could not hear anything from that spot on the river. So and then going to the Brady claim, the state has said that this was because Officer Wright had already written a report about seeing someone, that this would just, it was the same evidence, that the defense would have been aware of it. I would totally disagree with that. The Angel Beatty seeing someone at the crime scene at the time of the murder that fits the description of who Officer Wright saw is very different than just having Officer Wright's statement. That sighting of someone near the crime scene at the time of the murder was never even documented. So the defense could not have had access to it or determined it was just cumulative evidence. They never had access to it. It was never documented. With regard to the innocence claim, the statute with regard on newly discovered evidence specifically says that the determination can be used to determine guilt or innocence. The statute that gives the court the options for what they can do gives them the option to dismiss the charges. If someone's charges are dismissed, are they not innocent? And the referral to the Innocence Inquiry Commission, the Innocence Inquiry Commission was established because the MAR statute did not, with the procedural bars that are in place and the fact that you could have your claims denied without even having a hearing, that is why it was designed. It was to correct for those things in an innocence case, but it was not meant to replace the possibility that someone could be declared innocent by a trial court. The statute gives the trial court the power to grant any relief that they find appropriate after hearing the evidence. And in fact, in other cases, the trial court have found the defendant to be innocent. Can I answer any questions from your honors regarding any of the 5 substantive issues and the procedural issue?
No.
All right, I think we understand your arguments. Thank you, counsel.
Thank you.
Any rebuttal?
Can you hear me? Everybody hear me? Judge Zachary, responding to the question you asked me during my initial argument about where trial counsel said that IDS recommended Ostrowski, that appears at page 1111, going on to 1112. He's the expert that when I contacted IDS, that's the name they gave me. He was more than willing to meet, analyze. He did a good job. And then there's one other place on page 1238. I remember being told specifically about Dr. Ostrowski because he was local, he was close, he was a professor at UNC. He had been used before and approved by IDS. So that's the answer to the question you had asked me earlier.
Thank you.
This case is about the DNA evidence. The suggestion that there's some kind of difference between testing the evidence and analyzing the evidence is spurious. 15A-269 provides a mechanism for a defendant to bring to bear new science that allegedly undercuts DNA evidence that was presented at trial. That's the avenue that the defendant should take. That's the argument the defendant is making. The state would respectfully request that this court overturn trial court's order granting a new trial.
Counsel, let me ask you one quick question before you sit down. So suppose we were to remand for findings on ineffective assistance because we concluded there needed to be findings and resulting conclusions on more detailed findings and conclusions on prejudice. What's your position on, your friend from Mr. Carver says, in order to have meaningful appellate review, you also need to order findings of fact on some of the other issues, like the Brady violation. Seth, what's your position on that?
I don't think it's necessary. I mean, in order to do this, this court would first have to find that the trial court erred in rejecting those claims, that some of those claims have traction. They simply don't. I don't think there's even an allegation in the defendant's brief that the Napu and Brady claims were material. There's these allegations that the state knowingly suppressed evidence and knowingly put on false testimony. I don't think those claims are substantiated, but furthermore, there's been no showing that they were material to the verdict, that they would have made any difference to the conviction. So I would ask this court to limit itself to the 2 claims that are before it on the state's appeal, the IAC claim and the newly discovered evidence claim and allow the rejection of the remaining claims to stand.
All right, thank you, counsel. Ms. Muma, did you want to speak to the court?
Your Honor, I merely wanted to ask, since I had 3 minutes left, if I can respond to the evidence that's just been provided.
Well, we typically only allow rebuttal by the appellant, so no, I won't allow that. But if you want to direct the court to some information in the record or to additional authority, there's a mechanism for you to file a supplement.
Thank you, Your Honor.
Thank you. All right, with that, we will adjourn.
This session of the North Carolina Court of Appeals is now adjourned.
Thank you all.
Thank you, everyone.
Thank you.
Thank you, counsel.